Welcome to Whistle Where You Work. I'm Mark Cohen, Director of the Government Accountability Project. In a few minutes, we'll hear about a regulatory revolution aimed at deterring financial fraud. Guess who doesn't like it? But first, immigrant detention. Nearly 30,000 immigrants on any given day, 3 times the number during the late 1990s, are locked up. And many ex-detainees report they've been abused. Human rights advocates say detainees deserve better legal access and treatment consistent with international norms of decency. With us to discuss this are David Shapiro, staff attorney with the ACLU's National Prison Project, and Brittney Nystrom, Director of Policy and Legal Affairs at the National Immigration Forum. Welcome to Whistle Where You Work. Brittney, let's start with you. How big a problem is this? How extensive is the detention system in the United States for immigrants?
The immigration detention system is vast. On any given day, upwards of 30,000 immigrants are held by the Department of Homeland Security in a whole host of detention facilities. Throughout any given year, the department expects to detain nearly 400,000 individuals. It's a system that's constantly in flux. The types of facilities vary enormously as well. It includes county jails where the Department of Homeland Security essentially rents bed space for its immigration detainee population, as well as dedicated detention facilities that only hold immigrants and are often operated by private for-profit prison companies.
And how many facilities are we talking about?
It's a really good question. ICE started out 2010 with around 340 or so facilities. ICE is the component of the Department of Homeland Security that enforces the immigration laws. It stands for Immigration Customs Enforcement. Oh. So ICE holds detainees while they're waiting for deportation proceedings. And it had around 340 detention facilities that it could utilize at the beginning of this year. To its credit, the Department of Homeland Security acknowledged that that was a lot of facilities to be monitoring and overseeing, and they have begun reducing the number of facilities. It stands around 250 right now.
But you still have to think that with so many facilities, there's going to be a pretty big variety in how people are being treated there. What kind of conditions are people living under?
It really does vary across facilities. Some rural, isolated county jails have immigration detainees in virtually identical settings to those who are being held in criminal custody. So you would have immigrant detainees wearing jumpsuits, their shoelaces are removed, they have no outdoor recreation time, no contact visitation with their families. Some of the larger immigrant-only detention facilities have slightly more relaxed standards where there is outdoor recreation time. There might be more hours allotted to visitation, but conditions are really not that different from what you would expect in an incarcerated setting.
So a lot of people would say, look, these people came into our country illegally. Why are we spending resources to make them comfortable?
What's important to point out is that the immigration system in our country is a civil administrative process. And the purpose of immigration detention is not punishment. It is not a penal system. Instead, it is a civil system, which is a little unusual to think of locking people up for civil purposes. What's also important to remember is that these individuals are in the custody of the government, and the government has a responsibility to provide them with access to medical care, with basic rights to ensure that their proceedings are fair and just. And I don't think anyone would argue that having access to medical care and your lawyer is a luxury.
So who are these 30,000 people a day who are passing through this system?
The immigration detention population is as diverse as America, and it includes men, women, families, the elderly, the disabled. It also includes individuals who are survivors of torture who have fled to the United States seeking protection.
So there have been a lot of reports of abuse, David. And can you tell me about some of these reports? What are people telling the ACLU?
There have been a number of atrocious incidents of abuse in immigration detention. One that certainly sticks in my mind is the death of Francisco Castaneda. He was a detainee who was in ICE, Immigration and Customs Enforcement, for well over a year, made numerous complaints about lesions on his penis that were not being treated. He was repeatedly denied any sort of treatment, including a cancer biopsy. And that ultimately resulted in an amputation of his penis and later in his death. Another detainee named Boubacar Ba was bleeding internally inside his skull and was pleading for help for 15 hours because he needed emergency care. And he wasn't provided with that care, and as a result of that, he died. So there's a regular problem with lack of access to basic medical care in immigration detention. And there are all sorts of other abuses that occur with some regularity as well. At the Hutto facility in Texas, for example, women were being sexually assaulted while they were being transported from one location to another. And there are regular complaints about not having access in some cases to even see the sun or be outside at all for months or years of detention. Being placed in solitary isolation cells where you have basically no stimulus, no human contact. Being denied access to attorneys or opportunities to meet with families. There are a number of ongoing serious problems in immigration detention. And as Brittney mentioned, Secretary Morton has made important steps toward immigration detention reform and has announced that he will put into place a truly civil system of detention. But there's a lot that remains to be done on that front.
One of the things that Brittney mentioned was that among the people that are being detained are torture victims. Presumably these would be asylum seekers, and historically asylum seekers are to be treated under the law and under international law as a whole different stream of migrants than immigrants. Are we treating asylum seekers the same as illegal immigrants?
Yes, there's the immigration detention facilities. There are conditions do vary. There is a patchwork of them, but for the most part, there's no differentiation between the conditions that an asylum seeker is subject to, and that any other detained immigrant is subject to. And these conditions really are more or less indistinguishable from conditions in a prison or a jail.
Okay, and that illegal immigrant was with quotation marks around it, just so you know. You both mentioned that there have been improvements in the last year or so. Tell me about what those improvements are, and are they adequate?
There has certainly been a commitment of leadership to reforming the immigration detention system. However, most of the announced reforms remain on the drawing board, and implementation has been lagging. One of the improvements from this past summer was the activation of an online detainee locator system. For years, family members and attorneys had a difficult time even finding where their loved one or their client was being held. So now we have an online system where you can find out which jail or detention facility an individual is in. However, that doesn't provide access to information for individuals who are not computer savvy or may not have internet access.
And how is that being handled then?
The advocacy community is continuing to push for a 1-800 number or some additional access to that information, but again, it's enormously difficult to turn a huge system around. And yes, we are happy to see that detention reform has been given prioritization under the Obama administration, but we're a long way from achieving all of those reforms.
And you said that this is a civil system and that the people are not criminals a priori in this system. And there are efforts to create an alternative detention system as well, right? Tell me about that.
Really the only long-term solution to the immigration detention problem is to take alternatives to detention seriously. These are evidence-based solutions that have been proven effective to release people, but to make sure that they are subject to secure monitoring. And this has been shown to be effective.
Electronic monitoring?
It can include electronic monitoring. And it's been shown to be effective in preventing flight or escape, which is the very rationale that the government puts forward for immigration detention. It's much more humane. It's also much more cost effective. The bloated immigration detention system, which detains about 400,000 people total in the course of a year, costs almost $2 billion. And that's well over $100 per detainee per day. It's absolutely crippling to the budget. And these secure alternatives to detention are much more cost effective as well as just as secure.
So how much would they cost, and describe what they would look like?
I believe the figure is much lower, on the order of $20 to $30 a day. Or
I've seen reports as low as $12 a day, and it does depend on what type of alternative program you're talking about. If you have a onerous supervisory program that could include a GPS monitor strapped to your ankle and weekly check-ins with something akin to a probation officer, that's going to be more expensive. But if you're placing individuals in a system where they check in perhaps monthly, maybe over the telephone even, that's where the costs really start to drop.
And what is the period of detention? What is the status that we're attempting to determine here in making an ultimate determination about the fate of these individuals?
Generally, it's people who are detained or have pending immigration cases, for example, are awaiting a determination of their eligibility for asylum and are waiting for a determination about whether the government can deport them.
Mm-hmm. And how long does that usually take?
It varies a lot, but it can take months or even years. And there's been a real shift from a detention system that was designed really for short-term detention to a system where people are just spending longer and longer behind bars.
Okay, and so let's talk about fixes to the system. Some of the things have already been modified, or at least there have been movements in that direction, but what needs to happen in order to create a humane, effective system?
One reform that many groups are recommending is a bona fide risk assessment, where an individual's circumstances are considered at the point of apprehension. Is this person the sole caregiver for young children? Does this person have a chronic mental illness? Is this person a flight risk or a danger to the community? And then using that information to decide whether that person needs to be detained or not.
And is there efforts in Congress or within the bureaucracy to make these fixes?
Congress has been active in introducing a number of detention reform bills that seek to set a minimum standard of care for immigration detainees. However, we're entering a new congressional session, and it's up in the air as to which of those measures will be reintroduced and acted on.
Okay, and David, I want to ask you about a lawsuit that ACLU filed about unreported deaths in detention. Very significant. Tell me about that.
We've been involved in seeking records about deaths in immigration detention since 2007 and have been litigating this case for a number of years. It has brought to light preventable deaths that have occurred in ICE detention, such as, for example, the death of Boubacar Ba, who I mentioned earlier, and who we learned information about only through this request. It has not only brought to light some of the horrible conditions that have resulted in these deaths, it's also brought to light deaths that were completely unknown before, that Immigration Customs Enforcement itself had lost track of. Indeed, 10 deaths, nearly 10% of the deaths since 2003, ICE simply had lost track of. And so one of the important aspects of this litigation and getting these documents was that if we don't even know who has died in immigration detention, how are we going to make meaningful reforms that avoid preventable deaths in the future. We also worked with the New York Times to get these documents and the information that they contained, to get some of that information in the public record. And that has been one of the factors that has led to Secretary Morton and ICE announcing plans to move toward a civil system of detention.
And I should add that thanks to the dogged persistence of the ACLU and the New York Times, we do now believe that since 2003, 115 individuals have died while in DHS, or Department of Homeland Security, custody.
Well, many thanks to both Brittney Nystrom of the National Immigration Forum and David Shapiro of the ACLU Prison Project for reminding us what is out of the public eye is often out of the public mind. And when we come back, the corporate backlash against the SEC's new whistleblower program. Welcome back to Whistle Where You Work. When Wall Street went on a rampage of greed during the Bush years, where was the SEC, the Securities and Exchange Commission? Numerous whistleblowers say they tried to contact the agency only to be ignored or rebuffed. It took the Bernie Madoff scandal to get Congress to put on its oversight hat, and the recently passed financial reform bill, which empowers the SEC to write rules that bestow financial rewards on whistleblowers who disclose significant fraud. Not surprisingly, corporations are pushing back, calling the program unfair. With the SEC rules set to be finalized next April, this key whistleblower provision is up in the air. With us to discuss this is Jason Zuckerman of the Employment Law Group, a Washington, D.C. based law firm. Jason, welcome to Whistle Where You Work.
Well, Mark, thank you very much for having me on the show.
Tell us a little bit, some examples about whistleblowers who tried to alert the SEC in recent years about financial shenanigans on Wall Street.
I actually had a lot of clients who brought claims under the anti-retaliation provision of the Sarbanes-Oxley Act who had worked at large financial institutions. And they went to the SEC. It often went into a black hole. The SEC didn't do anything about it, or if they did, it would take years and years. And a very important issue is in the financial services industry, there are obviously a lot of smart people. Why didn't they blow the whistle on the widespread fraud that is really the primary cause of the current economic crisis? I would submit it's because they felt if they blew the whistle, they would lose their jobs and possibly their entire professional career in that industry. What the new act will do is give people a significant financial incentive to blow the whistle, and it'll also provide robust protection if an employer tries to retaliate against
Okay, well, let's talk about
the
this.
whistle.
Let's talk about the provisions of the bill. How does it provide protection for somebody who wants to speak out about wrongdoing that they see on the job?
If an individual blows the whistle either within the corporation or they go to the SEC and there's any adverse action, that could obviously be the termination of employment, but could also be a form of harassment. If that happens, they can bring a claim, they can go right into court, and they can get their job back, and they could also get their economic losses, for example, any of the back pay, what they would have earned if not for the employer having retaliated against them. And that's very important. Employees have to feel that they can blow the whistle, they can do the right thing and still keep their job. I want to just point out really quickly that the highly respected auditing firm KPMG about 2 years ago performed a survey. they concluded that 74%, 3 out of 4 employees in the corporations that were surveyed, personally witnessed improper or unethical or unlawful conduct within the prior year period of that KPMG survey, especially at a time of high unemployment where people are so concerned about being able to keep their job. It's important to provide a strong financial incentive for employees to blow the whistle and for them to know that if there is some adverse action as a result of that, they will have a claim.
All right, but that isn't in some ways even necessarily the most controversial provision in this reform, is it? There's what the corporations like to refer to as a bounty hunter provision. Tell me about that.
That actually has worked very well under a law that goes back to the time of President Abraham Lincoln. Under the False Claims Act, an individual who works at a U.S. government contractor can blow the whistle on fraud and can get a percent of the amount that the U.S. government is able to recover. In about 1986, the key TAM provisions of the False Claims Act were enhanced as a result of information that employees have brought to the Department of Justice. The government has recovered more than $24 billion under that act. So that's worked very well, and there actually is a program like that at the IRS now, too. The evidence is just overwhelmingly clear that if you do provide individuals with a significant financial incentive to blow the whistle, it's a lot more likely that the SEC will know about these violations. And it's important that the SEC know about these violations as early as possible so they could promptly halt it if there's an ongoing shareholder fraud or other SEC violation that could harm the public.
So how does it work in the SEC context, or how is it proposed to work in the SEC context?
The way it will work under Section 922 of the Dodd-Frank Act, if an individual voluntarily provides information that the SEC is not aware of, and that information leads to a successful enforcement action where the SEC is able to recover $1 million or more, the individual who blew the whistle can get an award of anywhere from 10 to 30% of the amount that the SEC is ultimately able to recover.
Well, the corporations are screaming, well, this is just going to generate disloyal employees, right? They're all going to see, I have a bigger payday by reporting some minor infraction at the company to the SEC than to try to remedy it within the corporation.
It's been my experience, and I've had a lot of clients who blew the whistle at corporations. My clients are not eager to have a lawsuit. They're not eager to get a reward. They want to do the right thing, and they want to see their employer do the right thing, and they want to keep their job, and they want to work there long term. I don't know of a lot of individuals who say, I want to blow the whistle. I think it's important for individuals to be able to go to the SEC because those internal compliance programs don't work at every corporation. I've had clients where they blew the whistle inside the corporation, and the response was that the employer either got rid of them, either they were significantly harassed, or the employer didn't do anything about the information. There will always be organizations that do have a good program in place to properly respond to employee complaints and to take appropriate actions. But there are going to be organizations like Enron, where you have the CEO, where you have upper management is at least partially responsible for the unlawful conduct. When you have an organization like that, individuals can blow the whistle all they want. The upper management is not going to do anything about it. So where you have organizations that don't have the right kind of program in place, like an organizational ombuds, those actually work very well. It's important individuals can go directly to the SEC. And I would just point out one more thing. If those programs did work well, I don't think we would have our current economic crisis. That is, those programs would have been aware of those concerns and would have handled them in an appropriate manner. If employers are concerned that employees will go to the SEC and not to the employer, then they now have an obvious then the obvious impact of this law is that employers will put the right kinds of programs in place where employees will believe that they can go to that program and their concern will be adequately dealt with and they will keep their job.
Okay, so let's say that I'm a loyal employee at a corporation. I don't want to hurt my company. I just want to fix a problem. But I also know that at the end of the day, I might want to be able to report this to the SEC and in fact benefit from this program. Do I lose my place in line if I go to my company first and report it?
No, what the SEC has proposed in these implementing regulations is that an individual will keep their place in line if they blow the whistle within the corporation. Then they have to give the corporation about a 90-day period to take action. And if the corporation does not take action at that point, the employee would go to the SEC, and it would be as though the the individual had brought the claim when the individual went to the SEC. I will just point out one.
Went to the corporation.
Yeah, went as though the individual had gone to the SEC at the time the individual went to the internal compliance program. Right. I will point out, unlike the key TAM provision of the False Claims Act, if the SEC does not act on the information that is provided by an individual who blows the whistle, that's the end of the line. One of the aspects of the False Claims Act that have worked and why the government has been able to get more than $24 billion as a result of the key TAM provision of the False Claims Act is that if the U.S. government does not intervene, if they do not take action to go after the U.S. government contractor involved in the fraud, the individual can pursue that action on behalf of the U.S. government. That won't be an option here.
All right. Well, the rules are being written as we speak at the SEC for how this program is actually going to be implemented. And there's a lot of pushback, as we mentioned, from the corporations. What should people do if they're concerned about preserving this program in its most empowered sense for whistleblowers?
I think the most important issue is going to be, does the U.S. Congress provide the SEC with the financial resources it will need for this program? What I'm hearing from the SEC is that they receive hundreds of these allegations every day. They simply don't have the resources in place to act on all of those allegations. It will be very important, and I understand from an article just the other day that there are efforts being made on the Hill to significantly increase the SEC's budget. If there isn't an increase, I think a lot of these allegations are going to go in the same black hole at the SEC that other allegations had gone into for years. And again, I would submit that that is at least partially why we have this current economic crisis. The SEC had opportunities to intervene, and they chose not to.
Well, many thanks to Jason Zuckerman of the Employment Law Group for reminding us of the high stakes in providing legal protections for financial whistleblowers. I'm Mark Cohen, and this has been Whistle Where You Work.